Hi, everybody. This is Arkady again. We got disconnected from the other live. I don't know, something with the internet. Hopefully, this one works better. So, everyone, I don't know if you're able to jump into this one, but yeah, we were talking about some questions. I know there was one question about a slip and fall or trip and fall in Texas, and it had like some radio frequency ablation, I believe, epidurals, right? Things like that, perk disc. So, I'm not familiar with Texas, but in New York, that would be worth, maybe even two, 300,000, maybe more. I've even had like over 500,000 for a perk disc. Now with, if it's a TBI though, that would change it, right? Because a TBI, a traumatic brain injury, would make it worth way more. Like even that would be worth the full policy of $1 million in that case. So yeah, I just wanted to answer that question. Sorry about that. I don't know what it was because the internet seems to be good, but for whatever reason, it just said that something was not connected. And then, oh yeah, Life is Good says that he's having or she's having a total hip replacement tomorrow. I'm curious how much it increases value in the state of New York, city of New York. Yeah, absolutely. I mean, total hip replacements, I've done many cases like that. I've settled them for even, I just did one recently, actually. It was a total hip replacement. I think we got about 1.25 million, 1.3 million. But the problem with that case, the reason we couldn't get more was because the client had an indication to have the hip replacement before the incident. So basically, he was working as a security guard in a building also in Manhattan. And his doctor already told him you're going to need a hip replacement. But then he fell due to like a defective condition on the roof. And then he sued, for the fall. So we tried to say the fall is what kind of aggravated or caused the hip replacement, but there were medical records saying that he was already needing it before he even fell. So it's kind of tough, but we still got 1.3, or I think 1.3 million because we argued that, well, he has, past pain and suffering, future pain and suffering, including loss of enjoyment of life, but he also has future medical costs, right? And those were like, well, close to $1 million. And you have to get an economist or a life care planner to give you the costs. And doctors sometimes will tell you what medical procedures will be needed, like an additional surgery, physical therapy, MRIs. So you want to definitely get the costs. You also sometimes have, depending on the case, lost salary, right? Lost wages. So add that to the case, right? Because that just increases the value. Now you have different categories, right? Each category, like past pain and suffering, maybe it's been like, 3 years since you fell, right? Or since you had your crash. So that's already going to be past pain and suffering. That already could be like 500,000. Future pain and suffering, depending on your age, if you're like, like my client that I'm doing the trial now, he's like 30 in his mid 30s. So he has like 40 future years. So 40 future years, that could be like, a lot of money. Even if you count it as, 100,000 a year, it's 4 million, right? If you count it as a million a year, it's 40 million. It's crazy. So that's a lot of money. So, you want to definitely hit the future pain and suffering, loss of enjoyment of life category. And then medical costs, depending on the injury. With a hip replacement, yeah, it could be up to 1 million, maybe even more, depending on what the medical procedures and treatments that the doctor says are needed. And then the economist will calculate that. So if like look at it that way, right? If the past is like, say, even less, right? The past could be 500,000. The future is like 2-3 million, and then you have 1 million in medicals. And I don't know if you have lost wages. So altogether, it could be like 5-6 million, right? It could be really big. So you could go for a big number, stick it to them, like the way I was talking about before with the settlement opportunity, saying this is your opportunity, pay this. If you don't, that's fine. But then once we go to trial, it won't be this anymore. Like, for example, pay me like 2 million now, but if once we go to trial, that's off the table, it's going to be 4. And here's why, because I have all these categories. When you add them up, it's like 6. So even 4 is a discount, right? So put them in the corner and really make them pay. That's what I like to do. And then Castellano says, hello, good evening. How are you? And Jay Frag says, hi. He says, we had spoken briefly in the past, wanted to give an update. My wife and I were in an elevator accident in December of 2021. Both needed spinal fusions, physical therapy, injections. I had to resign from my job. As a teacher in New York City, my wife is still teaching. Lawyers demanded 12.5 million. Venue is Atlantic County, New Jersey. It happened in a casino resort. Oh, yeah. That sounds like a serious case. Yeah, if you both had fusions and there's 2 different people. So yeah, absolutely. That should be that should be a good case. Good luck with that. That should be a good case. And Life is Good says, thank you. Yeah, I've had 12 major surgeries, including 2 prior arthroscopic surgeries on my hip that failed. Oh wow. So it's not just a knee, right? It's all this. So yeah, it's gonna be worth way more than. Yeah, that's a big case. That's a huge case. Yeah. Okay, let me see if there's any other questions. You know, if the yeah, so yeah, so that's basically what I was saying is like, you just want to maximize the categories because a lot of lawyers, like even that case, right, where I got the 1.3 million on the total knee or I'm sorry, the total hip replacement. What happened in that case was that there was a million in primary coverage. There was another 25 million in umbrella beyond that. But the first lawyer who had the case, he had an offer, I think, of like maybe under 600,000, and he was just pushing the client to take the 600,000. And then he knew about the million primary, right? Because that was disclosed in the preliminary conference order. But when we took over the case, the client came to us. Actually, I think it was from YouTube. The client came to us from YouTube. So we took over the case. We wrote the lawyer a letter and we said, what about, do you know if there's any excess umbrella or anything else? And he goes, well, I don't know. And I don't even care. Why would I care? He didn't even want to find out, right? And then we sent a letter to the defendants trying to find out. And they didn't want to tell us, but like after a while they did tell us, and it was 25 million. It was with Chubb. So, then we kind of got more than the million. We kind of more than doubled his, what he had. So yeah, I felt like it was a pretty good result, but you have to do these things. Sometimes people just don't do them. And yeah, if you're not going to ask about umbrella coverage, it's like you're just not even going to find out there's $25 million out there. And if you're not going to maximize the categories like the future medical costs, because it doesn't really take that much work. Paralegal could do it. You have to get an economist, you have to get the doctors to give you a narrative as to what the future costs will be, maybe a life care planner. But this is like, 3,000, 5,000. It's worth it, right, to spend 3,000 or 5,000, but then you're adding $1 million of extra value to the case. And just like I was giving my example with my trial, right, a lot of lawyers are not going to hire an appellate lawyer while they're on trial to give you advice about a motion, but then you're going to lose the motion, you're going to lose your expert, you're going to lose the whole case. So you have to you kind of have to spend money to make money. You have to have this kind of like vision that what you're doing is you're doing what's best for the client. You're just all in kind of. You have to be all in. Otherwise, yeah, your chances of losing are going to be much greater. So yeah. And then Jay Frags says, is it typical for a case this large to take this long? The defense keeps asking to extend discovery. Yeah, I mean, it's possible, definitely. I mean, they do take time. It's 2021. I don't know what stage you're in. It's probably better if you text me. We could do another call. We could discuss what specific stage you're in. Because if you already had defense depositions, maybe there's an IME, then you put it on the trial calendar. Just depends on where you are in the case. But yeah, I mean, they do take some time, but New Jersey, I believe, is pretty efficient. So it should be moving pretty quickly at this point. And he also says we had a court mandated mediation. They offered 50,000. Obviously, our attorneys walked away. Yeah, that's weird. Only 50,000. If you both had fusions, I mean, it should be into the millions. I don't know what their rationale. It's good to if they're going to do that, right? And if it's court ordered, you can't say no to it. But what I would do is when at that mediation, I would say, well, what's your reason for offering 50,000? You can't just give me just like people say you can't file a frivolous lawsuit. Well, you can't give me a frivolous offer. You can't put up a frivolous defense either, right? The idea of frivolous conduct or sanctionable conduct, where the judge actually sanctions you and says you have to pay money because this is frivolous, it applies to both sides, right? So ask them, why are you giving me a $50,000 offer? What's your good faith basis? Write me a letter, explain why is this only worth 50,000, and have your lawyer send them a letter and talk about all the categories like the future medical costs. With the fusion, you're going to have adjacent segment disease. So just that is like 300,000 for each surgery above and below the levels, right? And then, I had a 58-year-old who had a fusion at L5S1, only at one level, and his future medicals were like 2.7 million, just the future medicals. And then what about past pain and suffering, future pain and suffering, like we talked about, right? All the categories, lost wages if you have it. And just, maybe there's other categories, and just, and just say, look, when you add up all these categories, it's a high number. Maybe it's like 7 million. So why are you offering me 50,000? Just what's your good faith basis? And I would just try to, do it that way, kind of put them in the corner, because, they can't do frivolous conduct, have the judge, get mad at them. And then Castellano says, I'm afraid a jury won't like me despite being in Queens. How do you counter this lack of confidence? I lack confidence due to the questionable, very sense of self and identity that my injuries caused. Well, I mean, you just have to have your lawyer, make sure you have a trial lawyer, a good trial lawyer. Queens is fine. Queens has a lot of different, types of people, right? It's a melting pot. You have like your Asian community, your Spanish community, your Indian community. So, you have to speak to them and just see like, why do you think they're not going to like you? I mean, uh, the point is not like whether they like you or not. The point is like whether they could be fair, right? Whether they could judge the case neutrally for both sides, right? And it depends on what the facts of the case are, right? What happened if the defendant did something wrong, if they, for example, knew about something that was unsafe but chose not to fix it. Well, then if it's framed correctly, you could have the jury really not like them, right? Because they could have avoided everything and they chose not to. It's a choice not to be safe, right? So it just depends on what the case is about. But I wouldn't really worry about that. I mean, what you're saying is very general, so I don't really know how to answer it. But if you have a specific reason why they might not like you, or if you want to text me, I could give you a free consultation. It's 347-566-9595. But I wouldn't really worry about that because remember, it's not a popularity contest. It's more about whether they're able to follow the law, whether they're able to be neutral to both sides and, be fair-minded, basically. So you want to start out, evenly, and then they basically make the decision according to what the law is. The judge instructs them on the law. They have to answer questions. And it's kind of like crossing bridges, right? The first one will be, were the defendants negligent? So negligence means that they didn't, they weren't reasonably careful. So if they say yes, that's good. You're so far you're winning, right? And the second question, the second bridge, was the negligence a substantial factor in bringing about the injury, right? So was the fact that they were not reasonably careful or were not safe, was that a substantial factor or reason in bringing about either the injury or the incident, the accident, whatever the event was, right? If they say yes, now you're good on liability. Now the final question is, give an amount that's fair and reasonable for damages. And then they'll have the categories, right? Like pain and suffering, past and future, medical costs, whatever you prove, whatever you show as evidence. So yeah, it's critical. So it's not, like I said, it's not a popularity contest. I wouldn't really worry about that. And then Pearl says, is raw law every Tuesday? Yeah, I mean, I try to do it like, Tuesdays. Sometimes I do it on Mondays. I do whenever I have time, sometimes on Thursdays. Now I'm on trial, like I was saying in the first video. We had a bad connection, so I had to end the first video, but I'm on trial. So now it's a little bit like today I had like a day off because it's Veterans Day, and I pretty much was preparing some of my outlines, but I got done. So I thought, let me jump on for a few minutes and, get the channel revitalized because I felt like the channel was asleep a little bit. And then Life is Good says, let me just go back up for a second. Life is Good says, yeah, large cases tend to take long time. Mine's 8 years in the making. Yeah, that's long. And then Crypto says, good afternoon. What case value between pre-existing and fresh 100% liability, rear end ACDF, one level in New York City commercial truck? Yeah, so it's better probably to text me. I have to speak to you, then I could tell you. I can't really give you a real answer, like based on what you're writing, because it's very general. It's just not enough to give any kind of, I could tell you something, but it'll be wrong. So I don't want to, what's the point, right? It'll just be like mumbo jumbo kind of thing. Because like what you're saying is you had a pre-existing injury and there's 100% liability on the truck. So we'd have to know how much insurance the truck has, right? What's the primary, what's the excess? Is it like $1 million primary with $5 million excess? Who's the carrier? ACDF one level, and you're saying New York City meaning Manhattan. So yeah, ACDF one level could be worth like 1.5, 2.5. It depends on what all the damages are. Like I was explaining, past pain and suffering, future pain and suffering, whether you have future medical costs with an economist and a life care planner, whether you have lost wages, all the different categories, and how you maximize them, whether you have community witnesses like friends and family, neighbors, coworkers, talking about how this has affected your life, how you were before, how you are now, whether you have all this evidence, what doctors you have, what evidence you have, so all this, it's all like a big picture kind of thing. It's not like it also depends on who's handling it, right? If you have a good trial lawyer, you might get more. Like somebody that I know got like 9 million in Suffolk County for like a one level fusion, and that's a bad venue, and they got 9 million, so they're a good lawyer, right? But somebody else might go and do the same case and get like 20,000 or get a defense verdict and get 0. So it just depends on who's handling it as well. So I can help you with all that, but you have to like text me and it's free. So maybe I can't get maybe back to you right away because I'm on trial, but I'll do my best. It might take me a few days or maybe even like into next week sometime. And then JFrag says the IME wasn't done before the mediation, so I suppose they wanted to finish that process prior to giving a serious offer. Yeah, that's possible. They do like to do those IMEs, although what I see is those IMEs are always the same. They always say you're not hurt, or if you're hurt, it's not because of this, it's because of living your life or some other BS. But, Okay, Kenneth says, how long does it take my attorney to close out my case after treatment? They told me 30 to 90 days. Yeah, it just depends on like where you are, your venue, who the attorney is, what the attorney is doing to close out the case. Like, what do you mean by close out? You mean like settle? They're just trying to settle it like it's a soft tissue, and they're just basically trying to pick up the phone and get you some money, like 10 grand. That could take like a week or two, if that's all they're trying to do. Just depends on how you're defining close out. If you mean like litigate, it might be longer. It might be a year or two, right? Because you have to go through depositions, put it on the trial calendar. There's a wait to get to trial, depending on where you are. Like in the Bronx, people are waiting like 3 years to get a trial, so it can't be like 30 days. So it just, all these things are like very fact specific. So it's kind of hard to answer general questions like that. Okay, and then Bubakar says, I did my deposition 2 months ago, but no update in my case. Truck accident with 2 surgeries and doctors recommended another 2. It's been more than 2 years. I'm going to trial in Queens. Yeah, again, that's a good case, but if you're not getting any updates, that's not a good sign because the lawyer should be communicating with you. You should be able to like text them or speak to them or, but I don't know what kind of surgeries. You just said 2 surgeries, but, you have to know like what kind of surgeries because each surgery might have a completely different value. Like a knee scope will have like a value maybe of 250, 300, but a fusion might have a value of like 1.5, 2 million, right? So, but yeah, you could also text me. It's 347-566-9595. And then Kenneth says the insurance would only pay 30,000. Oh, okay, so it's probably a smaller case then. Probably it's only a 30,000 limit. So yeah, that's reasonable, 30 to 90 days just to settle it on the phone. And then Money says, question, why would my attorney 1 minute be all gun-ho after sat down with the defendants to discuss the settlement, which was lowball? I have a jury trial coming up and he's not communicating or responding. I don't know. It's hard for me to say like why other people don't respond. It could be he's having something going on, other cases, he's busy. It's hard for me to guess that. It'd be really and he sees a different attitude towards my case. It's all negative before we go in front of a jury. Well, maybe they're not a trial lawyer. Like there aren't that many trial lawyers. Trial lawyers are like very kind of like, it's few and far between kind of thing. It's kind of the few, the proud, the Marines, like the trial lawyers. There aren't that many of them. Like most lawyers are not trial lawyers. Most lawyers are just like going to settle the case because it's easy, right? You're going to get money. Like, okay, say for example, I have a case and it's $1 million policy. I could go to trial, which involves like a lot of work. It's like going to war. And then, maybe I'll get, I'll do well and I'll get the full $1 million, but maybe I won't and I'll get 0. But I'm taking that big risk and I have to put up like $50,000 of my own money to do that, right? Plus take that risk. But if they call me up and they say, hey, why don't you just take like 350? Well, I don't have to do anything. I don't have to put up 50K. I don't have to do a 2-week trial and risk losing and get 0. I just take 350K. I mean, of course, I have to pay the client, but I'm getting like over 100K in my pocket. It's easy money. And then guess what? They don't have one case. They have like, hundreds, or maybe some people have thousands of these cases. They're just like, let's just keep it rolling. 100K here, 200K there, 50K here. And why do I have to even set foot in a courtroom? It's just easy. So that's why they don't want to do it. But you have to research them because for you, it's not the best, right? For you, if you have a good case and you're trying to max out, you're trying to get full justice, you want to go to court, you're going to get a lot more. Like I've had cases where, they offered me 0, like literally 0. And I've done the trial. And then before the jury even came back, while we're doing the liability trial, they're offering me like 1.4, 1.5 million. I had another case where they were offering 0. And then before the trial, they're offering like 400,000. Then before we pick a jury, they're up to $1 million. And the judge is like yelling at my client, you better take that $1 million. She's actually threatening him to like, report him somewhere, that he's going to like lose his driving benefits if he doesn't take the $1 million. I just said, no, thank you. Let's go to trial. Pick a jury, put up a few witnesses, settled it for like 3.5 million. You get a lot more if you go to trial usually. I mean, every case is different. Some cases you want to go all the way and get a verdict. Some cases you have to get a verdict because there's no offer. but like you don't want to, like settle these cases for pennies on the dollar. Why? When you can get full value. And it just depends on, depends on the case, depends on your chances of success. Okay, and then Pearl says, is it very hurtful to my case that I waited 8 years after the accident before getting surgery? My trial date is coming up. I don't know if my attorney is exaggerating to try to convince me to settle. Well, I mean, it depends, right? If you had a case and the doctor said right away that you need the surgery and you just chose not to get it, but you needed it like right away, like a few months after the fall or after the crash, whatever it was, and then you ended up having it later, like 8 years, but the case is still pending, that would be better than if like nobody ever said you needed surgery, right? And you were just fine. And then all of a sudden, 8 years later, you're getting a surgery. Well, they're going to say, well, how do you prove that surgery is even from what happened 8 years ago? It might be from something else. You might have had another incident. It might be from living your life, right? So if there was an indication for surgery or a recommendation from surgery shortly after the incident, then I would say it's stronger for you. But yeah, and if they're trying to convince you to settle, I mean, some cases should be. A lot of cases, I mean, look, 95 or 98% of all cases do settle. It's just a question of how much are you going to settle for? Just because you go to trial doesn't mean you're not going to settle. It's just you're going to settle for more because you're going to put pressure on them. You're going to be in court. You're going to have a jury. They don't have anywhere else to run, So if they offer you like, I don't know, 50,000 now with a jury, if you start the trial, if you're doing a good job in the trial and you're scoring points, now that 50,000 might go into 500,000, right? So that's how it works. So you want to put pressure on them. And then Tekovid says, hi, Arkady, what should I expect after a deposition? The opposing counsel asked for a new demand letter. Is that a good sign? Yeah, that's good. Send them a letter, see what they offer you. A deposition is just a step in the process. That's when they get to question you, ask you questions about what happened and your injuries. So if the deposition went well, then it should give you a better chance to settle. And Castellanos says, why hasn't the defense cut me off from treating with my doctors? I thought that after a year of treatment, they cut you off and send you their doctors. A suit was filed by my trial lawyer. Well, I don't know. What do you mean by cut you off? You mean like with no fault? It's like a car accident? Usually they do. It's not really the defense that does it. It's more like the no fault carrier, because there's only a limited amount of benefits, like 50,000 in benefits. So once they send you to their doctors or the no fault IME, they're going to cut you off. That's usually what happens. But if they haven't cut you off, I mean, I wouldn't worry about that. That's a good thing. You can get more treatment. And then Tony says, hi, super lawyer, slip and fall, clear liability, 23 hours after stop, snowing, TBI, knee surgery, commercial insurance, already 2 years. How long can it take? Well, no, you see, the question would be like where the case is, like what status the case is in. If it's already on the trial calendar, maybe it'll take another month, right? If you're already on the calendar, you're going to get a date for trial. It could also settle at any point. So has your lawyer written a settlement opportunity letter, or what some people call a demand letter? I don't like the word demand, but settlement letter, basically. If you write one of those, that'll give them more chance that they're going to give you an offer and settle with you. So all these things, right? And also like what stage you're in. If you could be 2 years in, you could be 3 years in, but if they haven't even done depositions, well, you still have to do depositions, right? It's like a process, right? It's like steps in the process. It depends on where you are. Let's say the process is from 1 to 10, but if you're on step 2, you could be like 8 years already. But if you're still on step 2, well, you're here. You're in step 2. You have to be here, right? Step 10 or step 9 to settle. I mean, you could settle in step 2. Usually it's going to be less value unless they're like scared of your trial lawyer and he's like really good and he's getting like, $1 million verdicts. So it's not a question of how much time, right? You could be 8 years from the accident, but still be in step 2 if you haven't had like depositions of the plaintiff, depositions of the defendant, IMEs. Are you on the trial calendar? Like all these. That's why I was saying it's probably better to just text me for a consult, because then it's much more, we get a lot more done, as opposed to like, this, because it's kind of hard for me to answer because it's very general. Okay, Tekovan says, I know you were in trial prep. How is that going? Did you already went for trial? Oh yeah, no, I'm in trial now. So we're doing motions and limine. I actually started talking about it in the first video, but we had like a bad transmission, so I had to start a new live. I think that one might be up there. You could watch that one too. It was short, but I think that part, hopefully, about the trial was, we had a bad internet connection or something, but hopefully that part about the trial went through. I basically just said that we were just doing motions and limine. So they were trying to like preclude a liability expert, the other side, but the judge, allowed us to call the liability expert. Now they're trying to preclude our life care planner, which I think we should also win, but who knows? And it's just like going kind of like a roller coaster, right? You never know. What we thought was not even an issue has become an issue. And what we thought was an issue that we might even lose, because there were like 7 or 8 motions in limine. So far, we've won all of them. But there was one that I thought was like we might lose. And, it's okay. Look, you can lose 1 out of 8, right? But we won that one too. So it's good. So everything's going well. And then hopefully like tomorrow, we get to start picking our jury, because the way this judge is doing it is she's, resolving all the motions in limine, which means like, what comes into evidence. Like, for example, who's going to be allowed to testify, what comes into evidence first. And the way they're doing it, most judges, like, they just do this, motions in limine. They might do them all in like an hour or I don't know, 2 hours. But we're spending like a week. We started last Wednesday. We spent like over a week already on these motions in limine, because we argue them. First, we file them. So we put all our memorandum of law, cases, precedents. We file them. Then she reads them. Then we argue them. Then she takes time and she says, come back tomorrow at like noon, and I'm going to give you a written decision. So she has her law secretary and her, they type up a written decision. And there were like 8 of them. So they were like putting the orders, and then putting like yellow paper in between, and then another order. So it's all nice and organized. It's like a whole like, wow, almost like, I mean, it's good. It's good. They're really like doing it the right way, but it's just taking so long. It's been a week. Some trials are over in a week, and we're doing motions in limine for a week. So yeah, that I'm a little bit, and it's tough because we have some scheduling issues, because Thanksgiving is coming up and some of our experts are going to be away. So now I'm like worried that we are either going to have to do video depositions, or, I don't know, because like we can't lose our experts, and doctors and the other people, they're not going to be here anymore. So if they're not here, that's not going to be, I don't know. So basically that we have to speak to her tomorrow, because the scheduling is the toughest part. And then HH says, great videos. I'm the plaintiff in a med mal case in Nassau County. My attorney has filed a summons and complaint, and the defendant has filed an answer. That being said, what is the next step? Yeah, so you'll get depositions. You'll have to file first a request for preliminary conference. And so then you'll have a preliminary conference. That's the first meeting with the judge. And that'll be like an order where they'll say deposition of plaintiff on X date, deposition of defendant on Y date. You give them your medical records. They give you whatever your attorney asks for. I guess their medical records. I don't know, whatever they ask for. Usually medical records in a med mal case. And then that's basically it. Then you do depositions, and then once all discovery is done, both the paperwork and the depositions, you put it on the trial calendar. And the good thing about Nassau is it's not that long, so it moves pretty quickly. So you should get a trial date fairly quickly. Both the discovery and the trial date after you certify as trial ready are all fairly quick. Some of the quickest in New York, actually. I don't know any place that's really much quicker than Nassau. Now, the bad thing about Nassau is it's not really a good plaintiff's venue. A lot of people there are conservative, and so you have to have a good trial attorney who could really explain what the practice was, like what the medical negligence was, and how that caused your injuries, so you can either settle it or get like a nice verdict, because the juries there tend to be generally speaking, of course, you could pick a good jury if you are a good attorney who knows how to speak to jurors and how to select the right jurors. But generally speaking, Nassau County is not like a great venue. You don't want to be there unless you have to. Castellanos says, I'm confused. I thought that people you were suing cut you off from treatment. Someone crashed into the back of my car a year ago. I thought their lawyers cut me off from treatment at some point. I don't know. It depends on how it works. I don't know where you are. Like in New York, it doesn't work that way. In New York, the people you're suing don't cut you off from treatment, because, depending on what kind of case, if it's a car crash, basically, it's just no fault, right? PIP, personal injury protection. So it's your own policy. Like say I have Geico, let's say, right? And somebody hits me in the rear, that person has Allstate. So I'm going to sue Allstate, but Allstate can't cut me off from treatment. I'm getting treatment from Geico from my own no fault up to $50,000. The only way I get cut off is if I spend all $50,000, then I just get cut off. Or if Geico sends me to their doctor and their doctor says, well, you don't need any more treatment. Well, then, I have to go back to my doctor and say, yes, I do, and then fight with them with arbitrations, or I just have to stop, right? Or I have to treat using some other method. Like I forget about no fault, I treat under my health insurance, or, whatever. That's how it works in New York. But you might be in another state. In another state, it could work differently. I don't know, but I haven't really heard too much about that. How would they cut you off from treatment? Because they're not holding any kind of ability, because you're treating with your treating doctors. They're just the people that caused the wreck, right? So, or whatever it was, this with the unsafe condition that caused you to fall, or they hit you in the rear. So how would they be able to control your treatment? Your treatment is with your treating doctors. It's either through your, workers' comp, or your no fault, or your PIP, or what, or your health insurance, or on a lien basis. So they wouldn't have any way to control your treatment. So I'm not really following why you thought that. Okay, Larry says, hi, Mr. Arkady. Is it common to settle cases after depositions? And like, how many months does it take to settle in your experience? Yeah, it's common after depositions. You could settle at any time. You could settle before depositions. You could settle before you file a lawsuit. I mean, it just depends, right? Every case is different. So there's not really anything that is always the same. But yeah, usually after depositions, because depositions is their chance to ask you questions like what happened, right? What your injury is, what doctors did you go to, and assess you, how you are as a witness. Do you answer questions? Do you not answer questions? Do you unable to answer questions? Are you like not understanding questions? Are you a good witness, a bad witness? So it gives them a little chance to evaluate you, right? So then usually after depositions, because then they have an IME, and then once all discovery is done, you go on the trial calendar. So at this point, there's nothing else for them to do. Either they're going to settle or they're going to get a trial. So, unless they are confident that they could win at trial, they're probably going to, settle after depositions. And then HH says, my wife and I are plaintiffs in a med mal case. Are we allowed to be there during each other's depositions? Yeah, you could be there because you're like the parties. Yeah, the parties could be there if it's the same case. Yeah, you could be there. And then Pearl says, what are motions in limine? Right, so I was explaining. So that's just basically what I was saying. Like when you make a motion to exclude like a certain type of evidence, like they made a motion to exclude our liability expert, because our case is about police officer driving in emergencies, like when police officers always say go into like a burglary, right, and they have to run a red light. So we have an expert, and they tried to say, no, that expert can't talk about that because the jurors know about driving. It's just common knowledge, but it's not common knowledge. Right? Jurors don't chasing, perpetrators at high speeds and running red lights. So we won, right? And another one, they're trying to preclude our life care plan. And we had some motions, like I wanted to use demonstratives and videos, and we had like animations. I wanted to use it an opening statement, and they said no because it's not evidence. But the judge said we could use it as long as we laid a foundation before, we did like an offer of proof. So things like that. It's just basically what's going to happen, kind of like setting the stage. Who's actually going to testify? Who's going to be excluded? That's usually what motions in limine are about. And then Ever says, what is the percentage of New York personal injury attorney? Oh, you mean like the percentage that they charge? Usually it's 33%. And then Rain Dream says, did my deposition 3 weeks ago, what are the next steps and how long will the trial? Venues in the Bronx. Well, yeah, I'm in the Bronx on my trial. The Bronx is slow. I mean, you could be 2-3 more years, even when you're certified as trial ready. The next step after deposition would be that your lawyer has to take the deposition of the defendant. You have to certify the case as trial ready, but you have to also make sure other things are done, like the IMEs. So once everything's done, you certify it as trial ready, and then you're still going to be maybe. But you don't necessarily have to wait like another 3 or 4 years, because while you're on the calendar, you could also settle. You just have to send them a settlement letter, call them. Always keep the case moving. If you sleep on the case, it could take 10 years, it could take 20 years, right? Nothing's going to happen. And then Tony says the lawyers can go to every insurance, have the property owner, he's at fault, take care of the right property in the lease. He's supposed to clean the ice. Yeah, that's true. They're supposed to do that. And then Will Glow says, my deposition is in a few days. Any pointers? Yeah, you can take a look at the video I did. It's called Super Depositions. Actually, it goes into depth. It's like 40 minutes. It goes into depth with some of the questions and some of the tricks. Take a look at that video, Super Depositions. That usually will answer. And then Short Guy says, hey, Arkady, I texted you about my attorney, Brett, and never got back to me. Oh, yeah, because I've been on trials. I've been a little busy. I have to research that. I'll try to do it maybe next week or so when my trial is over. But yeah, I have to get into the verdict search and research the attorney. I'll try to get to that. And Castellano says, I'm confused still. So what is the defense attorney representing the at-fault people ask you to go to their doctors? Isn't that when they write a frivolous report? Oh, no. So that's different, right? So the reason they ask you to go to their doctor is because then their doctor is going to testify at trial and say that you're not hurt, or if you are hurt, it's not because of the crash or your injury, it's because of just living your life, like degenerative disc disease. So they're not going to cut you off from treatment. You could get treatment. That's up to you. What they're going to do is just argue that based on that IME, independent medical exam, it's not really independent. It's really a DME, defense medical exam. It's their hired gun, right? They're just going to say that you're not hurt, and that's going to be their doctor. Because think about it. If they didn't send you to this DME, it would just be your doctors, right? Your treating doctors, your experts, whoever you have. And who would they have? They don't have anybody. How would they be able to get a doctor to talk about your injuries without even examining you? That's why they have the right to send you to their doctor to examine you one time. So they would have a doctor, because otherwise it's like you have a doctor, they don't have a doctor. It's not fair, right? So that's why that's the idea. But it's nothing to do with cutting you off or stopping you from getting medical care. It's just their opinion that you're not hurt or you're not hurt from this. And then HH Dog says, at what point should my attorney be preparing my story? I mean, I think as early as possible, but definitely before the depositions, you could talk about it. And then Manny Haas says, we were granted a motion to consolidate. We were suing New York City and the contractor. Does this now mean that we can only collect the insurance from the contractor? No, consolidate just means that both cases are in one. So you still sue both. It's just they're in one case as opposed to, being in two separate cases. And Come Along with Uncle Joe says, defense insurance rep said she needs to get a supervisor to approve her amount. Is that good or bad or neither? Well, I mean, if she has like a high amount, so high that she can't even approve it, that's good. If they're trying to get a supervisor to approve it, that sounds good. And then HH Dog says, oh no, we did that one, right? The story. Yeah, I think as early as possible, but it depends on the lawyer. Some lawyers most lawyers don't do stories at all. Like, it's just something I recommend because I think it's better, especially if you're going to trial, but most lawyers don't do stories. They don't really do, because you have to do like a deep dive, right? You have to go to the client's house, find out about them, who are your friends, who are your neighbors, who are your coworkers. Then you have to interview those people. You have to call them. It's like a lot of work. It's a deep dive. And Pearl says, my cousin was injured in an Uber that got into an accident. Have you heard about successful cases against Uber in New York? Yeah, of course. Yeah, they could be successful. Uber is good. I mean, New York City, it could be limited, right? Because New York City, I believe they have to follow those TLC. So it's only 100,000. But if you're in like Westchester or outside the city, Long Island, then it could be much better, because then it could be 1 million or into the even higher. So those are much better. Okay, everyone, I guess I better run because I got to finish up some stuff and I got to go back to court tomorrow. But I'll try to do another one maybe like later this week if we get another day off, but unlikely, probably next week. Hopefully I could do another one if we get like a little bit of a day off or a short day. But yeah, just text me. And if I don't respond right away, maybe what I'll do if you need me right away is I could also have my intake team speak to you, because they're good. What they could do is they could find out all the facts. And if you need specific help, like if you need a referral to an attorney, if you're not in New York, if you're in New York, we could help you. If you're not in New York, if you're in like Florida, California, wherever you are, we could have our intake team help, because we have a whole nice, group of attorneys, and they're all trial attorneys, and they're all like really, really good. So if you need that, my intake team could help with that. Okay, everyone, have a great night. Feel better if you're injured. If you have a case, I wish you maximum justice and full justice and the best result. Okay, please like and subscribe to our channel. All the best. Bye-bye.